Rick, are you able to stand in for this plea?
Sure, it took me a second. I think that's an opportunity.
Yes.
V1. Cold open curveball. 30 seconds in and Judge Boyd is already roasting somebody's last name pronunciation like it's a lost episode of Chopped. Notice how he frames it as an opportunity. That's classic Boyd psychology. Translation. If you can't say your own name right, the court's confidence in you just dropped faster than Spectrum's promotional pricing. Quick poll. Would you risk mispronouncing your own name in front of this bench? Or are you asking for a continuance to phone mom?
All right, the court is calling 2025 CR 004180, State versus Diana LeCompte. Could I have parties announce?
Rick Pena for the state of Texas.
Nick Aguilar on behalf of the Honorable Diana LeCompte.
And how do you pronounce your last name? There's no, all right, you're not doing that? She's not from Louisiana, okay.
Well, she says she is.
Oh, yeah.
It's not the correct pronunciation. What is your family doing? Come on, Mom. Teach you have to teach. Oh, no, don't come forward. Yeah, you got to teach your daughter better with the pronunciation. No. Yeah, let me just tell you.
Yes, ma'am.
We're off the record.
How should I pronounce it from now on?
Put that accent over that E. All right, so we're back on the record. Counsel, have you received all the discovery in this case?
Yes, Your Honor.
And did you review it with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. And is there an application in this case?
Yes, Your Honor. This should be up there. I found it in my notes a few minutes ago.
All right. Did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Record scratch. Why is the DA slipping citizenship Louisiana into a Texas plea form? Boyd's spidey sense is tingling for a reason. Any misstatement on these docs can torpedo the plea later. Fun fact. If the judge accepts a factual error, the appellate court can unwind the whole deal. So yes, that tiny box matters more than the $2,000 fine. Drop a comment. Should courts have to reread every blank aloud? Or is that just more paperwork theater?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, you're proceeding on the indictment as presented, correct?
Yes, Your Honor.
All right. Did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places? Did you understand your charge of possession of a controlled substance penalty group 1 gram to 4 grams as a third-degree felony? Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with, why are you putting citizenship Louisiana on this paper?
I always do that, Judge, just so the judge knows I asked. Always put in state.
Okay, all right.
When you see that, you'll see it on all my. I always make a note there so they know I asked.
Oh, okay. I was like, are you just doing that?
Another country.
Well,
Not yet. Okay.
You know where that's at.
All right. Did you understand by entering this plea, the court does not have to follow your plea bargain agreement if for any reason the court doesn't follow your plea and gives you more than you bargained for? The fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Very much so, yes.
Do you believe she's currently competent and is legally sane at the time of the offense?
Yes, Judge.
Has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her rights to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
I did.
Okay. According to the plea, punishment is to be assessed at a $2,000 fine. The state is recommending deferred adjudication, and there's to be restitution for drug testing. Did you understand that to be the plea?
Maybe.
Oh, well, let me go over it. So, according to your plea bargain agreement, there's a $2,000 fine.
Yes.
The state is recommending that you be placed on a form of probation that's called deferred adjudication. Did you understand that?
Yes.
and they're asking for restitution. And the restitution is supposed to be for the drug testing. Do you understand?
Yes.
They don't have an amount for the drug testing because it's not in the police report how much it costs to test the drugs. Do you understand that to be your plea?
Yes.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, were there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There be a TAP evaluation and 150 hours of community service restitution. Did you understand that was a recommendation from the state and the court does not have to follow those recommendations? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Sidebar. Listen to the defense pivot from abusive relationship to self-medicating. That's not just empathy. It's a statutory Hail Mary. Texas allows sudden passion mitigation only if the trauma narrative lands before sentencing. BOYD's follow-up about employment at Spectrum. He's sniffing out ability to pay for that fine. Translation. He's deciding whether the defendant can bankroll her own second chance or whether community service is the cheaper ticket. Legal Eagles, hit pause. Does tying fines to paycheck size equal justice or a two-tier system?
State, any evidence?
Yes, Your Honor. At this time, State offers into evidence, State Exhibit 1 with all attachments.
All right, State, you may be excused.
Thank you, Your Honor.
Judge, we have no.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. All right, proceeding with sentencing.
If you would consider that, yes.
All right, anything you wish to say on behalf of your client?
Judge, Diana was in an abusive relationship. She admits that she did one of the drugs in her stock. She tells me she was self-medicating to help her through the relationship she was in. It's never been in trouble before that I'm aware of. So it took a bit to get through to understand the deferred concept, or deferred adjudication supervision concept. She would like you to consider granting her the deferred adjudication for a period of time.
All right, are you employed?
Yes.
What do you do?
I'm a sales agent.
And what are you selling?
Spectrum. Spectrum.
Spectrum.
Yes.
Okay. Spectrum does keep going up on their prices. Nobody knows. They get you in with the contract and then prices rise. So I've heard. How long have you been working there?
I just started, it's my 4th week.
The last time we were here in quarantine, we got out of here quick so that you could get her orientation that was.
All right. And how many children do you have?
3,
What are their ages?
25, 22, and 17.
All right. And do they still live with you?
No,
Where's the 17-year-old? Who's he with?
he's with his dad.
And if you're drug tested today, what are the results going to be?
I'll pass.
When's the last time you used?
2024.
Okay. All right. This is what the court is going to do. There's a $2,000 fine. That would be probated. 4 years deferred adjudication. 150 hours of community service restitution. And you know what? Even though he's 17, I'm going to ask for the parenting classes. You can never go wrong with the parenting class. Once you complete the parenting classes, the 150 hours of community service restitution will be deemed satisfied. Now, if you don't want the parenting classes, your other option is to work in the Texas heat for 150 hours.
Yeah, I don't mind classes either.
Okay. So there has to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors. Do you have to go to work today?
Oh, yes.
Okay. Then we'll do a UA tomorrow. There'll be field visits one time per month for 4 months. TAP evaluation, out of custody, follow TAP recommendations. If TAP recommends inpatient treatment, we can start with intensive outpatient treatment.
I did all that. I did outpatient.
Oh, just give that information to them. Okay. But what the TAP evaluation is, it's just some questions you need to answer and they'll make a decision. They may say you don't need anything. All right, probation, is there anything else? Is there anything else you need from the court in order to be successful?
Just a question, if I can take the UA today, that way I don't have to miss tomorrow too.
Sure, you can take a UA today. All right. Anything else?
Will somebody give her guidance on where to take that UA?
Yes. All right. Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it? All right. Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
I understand.
All right. We can go off the record. In this court, communication is key to be successful on probation. If you have an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to the court. All right. All right. Good luck to you.
Thank you so
All
much.
right. You're welcome. All right. Mick, you were great as far as the testing.
I think we'll be fine today.
Yes.
Thank you, Judge.
You're welcome. Vashon, are you ready for this one? It's a probation application. All right. The court is calling 2024 CR 0126. I think this is one. Let me see, the writing is faded. Just 1 second. 012615, State versus Jalen Zavala. Can I have parties announce?
Yes, Jason Garrett here for the state, Your Honor.
And are you Ms. Zavala?
Yes.
Counsel, have you received all discovery? Did you review it with your client? Court will find that the state is in compliance with discovery. Ms. Zavala, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Judge.
State, are you proceeding on the indictment as presented?
No, Your Honor, we're proceeding on a lesser included DWI first, Class B misdemeanor.
Any objection?
No objection.
All right, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Did you understand the state is proceeding on driving while intoxicated as a Class B misdemeanor? Range of punishment is up to $2,000 fine and up to 180 days in the Bexar County Jail. Did you understand?
Yes.
If you have a plea bargain agreement with the state, the court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? You're going to need to speak up so I can hear.
Yes.
Did you understand by entering this plea you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do.
Ms. Zavala, has anyone threatened, coerced you, or placed you in fear to get you to enter this plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on the DWI first. Punishment is to be assessed at 180 days in the Bexar County Jail. There's a $500 fine. State recommends community supervision. There's to be restitution to Adrian Harrison in the amount of $2,000. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
I know, Your Honor.
Outside the agreement, the state is recommending that your community supervision be for a term of 2 years. There'll be a TAP evaluation, 100 hours community service restitution, and ignition interlock. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, any evidence?
Yes, Your Honor. State Exhibit number 1 with all of its attachments.
No.
All right, state, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence States Exhibits 1 and attachments, and the court will review the same. All right, after reviewing States Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty of the lesser included offense. Are you proceeding with sentencing?
Yeah.
Anything you wish to say on behalf of your client? All right, are you employed?
Yes.
What do you do?
My set appointments for vacation. It's called resort vacations.
Okay.
Mic drop moment. Boyd is essentially delivering a TED Talk on DWI physics. Intoxicated driver survives. Innocent passenger doesn't. He's stacking the record with findings that will bulletproof this sentence on appeal. Notice how he makes the defendant admit she cannot drink at all. That language mirrors the lifetime alcohol conditions appellate courts love to uphold. Audience question. Is a judge ethically bound to scare you straight, or is this emotional sentencing over the line?
And how many children do you have?
Just one.
And where is the child now?
At home. What is that?
And do you and the father live together?
Yes.
So what have you been doing since this incident happened? How have you changed your life?
Been working, staying home, following my orders.
Mm-hmm.
As for pre-trial drug testing every week, and
So how did you come to be in this place with driving?
I got dropped off.
And then, not today, I'm so sorry. That's my fault for not being clear. I'm talking about the incident when this happened. So how did this come to be that you have the child in the vehicle and you're intoxicated?
I'm sorry, I'm confused by the question.
All right, so according to this, you were driving a vehicle.
Mhm.
You were intoxicated. A child was in the vehicle with you. How did all of that happen? Why were you drinking and driving with a child in the vehicle?
I was dropping off my friend home. I had asked his dad to watch him, but he was going to end up leaving with his friend, so I had no choice but to take my son.
No, that's where you tell the friend, hey, I've been drinking. You're going to have to find your own ride. Here's an Uber, or you're going to have to spend the night here. And the reason why I want you to think about what you did is because anything could have happened. And I haven't done any research on this. My statistics professor will be very upset for me saying this because I haven't done the research. But usually what ends up happening when people get in an accident and they're intoxicated, passengers are always injured, or either passengers die. Usually the person who's intoxicated, they're just fine. And you know what ends up happening? They come to court, they're crying, they're upset because either they killed their best friend who's in the vehicle with them, or either they killed somebody who's just trying to get home. You understand?
Yes, I understand.
So you're one of those people who cannot drink. Your attorney, how long have you been practicing? A long time, right?
Yes.
So this is what I can tell you. I don't think your attorney has ever represented anybody who was charged with DWI and they tell her, you know what, my intention was to drink to intoxication and to kill somebody or to hit somebody or to get pulled over for driving while intoxicated. That's one of the crimes where nobody intends for that to happen, but it ends up happening. So you're one of the people who cannot drink alcohol at all because you don't know when to stop. You understand?
Yes.
And while you're on this probation, you're not allowed to drink at all. You understand?
Yes, ma'am.
So have you been taking classes or doing anything?
Yes, I've been doing the AA meetings. I'm still doing them.
All right. Are you enjoying the AA meetings, getting to know people? And
Yes.
okay. All right. This is what the court is going to do. There's a $500 fine that will be probated. 180 days in the Bexar County Jail, suspended and probated for 2 years, regular reporting by Zoom or in person, regular random UAs, 100 hours of community service restitution. I'm going to order parenting classes. Once you complete the parenting classes, 50 of those hours will be deemed satisfied. The other 50 hours, I'm going to ask her to do 50 sober meetings in 50 days, and that will take care of the remaining community service hours. You understand?
Yes, ma'am.
There's going to be a TAP evaluation out of custody, follow recommendations. There's to be the ignition interlock state. How long did you want the ignition interlock?
As we have left it up to the court, but generally we ask for half the term.
All right, I'll set the ignition interlock counsel at half the term. If she's doing well, I may change that.
So she's not operating a motor vehicle. She doesn't have one. Hers totaled in the accident. We can request a PAM in lieu of the ignition interlock.
All right.
And an affidavit of non-driving, I suppose.
All right. So it'll be probation. It'll be ignition interlock for half the term, or it'll be PAM for half the term with an affidavit of non-driving. Is there any vehicle at that home?
Just my son's dad.
All right. So it's going to have to be ignition interlock.
On that vehicle, she has access to it.
Yes. All right. Probation. It's going to be ignition interlock for half the term because there's access to a vehicle at the home. And then you all want to talk about this driver's license suspension, minimum 90, maximum 180.
The state will be requesting 90 days, Your Honor.
All right, so there's going to be a driver's license suspension for 90 days. And there is to be restitution, if any, to Adrian. Oh, thank you, probation. Thank you, state.
Yes.
Adrian Harrison. All right, sure.
And can she be given credit for the 90 days that her license was already suspended? She did consent to that breath test and it came back 0.01, 0.02.
All right, there's to be restitution, if any, to Adrian Harrison of $2,000, a DWI education course, and Victim Impact Panel Live.
Welcome to the mental health maze. Boyd just told us the quiet part out loud. The jail is really not the place for people who have mental health illnesses. Yet legally his hands are tied until the new violent offense is resolved. Thank the competency before placement rule. Mom's plea for hospital transfer. She's actually asking for a memo hearing, but without an attorney's motion, it's dead on arrival. Heartbreak homework. Should legislatures fund secure treatment beds, or is public safety the higher priority?
Probation, is there anything else? Well, they have this listed as restitution, if any, but both parties have agreed to $2,000.
Correct.
Is that correct?
That is correct, Josh.
All right, so both have agreed to $2,000, even though they put if any.
Yeah.
But the most is $2,000 because that's what everybody has agreed to. But it could potentially end up being less. All right. Anything else? They've agreed to a total of $2,000.
And that's it.
That's it. But the person may end up giving you bills that are less than $2,000. So,
still want to say
yes.
nothing from the.
All right. Anything else you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. So the reason why I said to them the $2,000 at the max, because sometimes people will turn in information and it'll end up being less than the $2,000. So, all right.
Sure.
Yes. Proof of employment within 30 days, no employment as a home health care provider with minors. Do you think in this case we need field visits? What are you thinking?
I would say for at least 3 months.
All right, thank you. And then field visits 1 time per month for 3 months.
What that is?
Oh, that's where probation comes out to your house, just to make sure everything is going the way it should be, okay?
Okay.
All right, in this courtroom, to be successful on probation, communication is key. If you have an issue, let your probation officer know about it. If you feel they're not addressing it, you can come in and address it with me, okay?
Okay.
All right, good luck to you, all right?
Thank you.
You're welcome.
Thank you, Judge.
Thanks, counsel. Hello, Mr. Lampkin. Oh, could you all address yes, thank you.
Hi.
All right, so this is what ended up happening this morning. The bus broke down, so they couldn't transport him over. Then there were some issues, and I'm sure, as you can understand, sometimes when people have mental health issues, it has to be a regimented schedule, and when things go off kilter, everything goes off kilter. So I was told that you had some concerns about his physical well-being. So the deputies, I asked them to call over to the jail. Deputy Laura called over there to see what's going on. I asked the court coordinator to have him by Zoom so that you can see him.
Thank you.
So you're welcome. So Deputy Laura, is he okay at the jail? And what I can tell you in this court, if somebody wasn't doing well at the jail, anytime somebody tells me, it could be the parents, it could be the relative, they'll let me know. If they think that something's wrong at the jail, I'll ask the deputies here, who I trust, to call over there to see what's going on. And they will give me detail, because at the jail, especially when you have persons who have mental health issues, everything has to be documented, because otherwise you'll get in trouble with the government. So everything is documented. So he's doing okay. The reason why he wasn't here is because the bus broke down.
Yes.
And there's not another bus for him. So his attorney, Michael DeLeon, is still working on trying to get everything arranged so he and the state can come together on what will be an appropriate outcome for these cases.
Yes.
So that's what he's working on. And as you all know, when you're dealing with mental health or physical health or something of that nature, it takes longer. So we're going to come back, Mr. Lampkin. We're going to come back on your case on the 22nd, all right?
I just have a question.
Sure.
Why are they treating me like this at the show? Like, I haven't been able to shower.
Right, so I'm gonna talk to them about your ability to shower, but what I can tell you is when you're dressed in a red outfit, like you're dressed in, they only allow you out of your cell at certain times. And then during that time frame, you have a chance, you're supposed to shower, and then they have for you to do an activity. But, I know everybody wishes the shower time could be longer, but when you think about the number of inmates they have at the jail, they can't give somebody a 30-minute shower. So I will check, Mr. Lampkin, I will check, and I will call the sheriff, and I will check on whether or not you're being allowed to shower, and I will do that today.
Can I please say something?
Sure.
Can we ask Malik if he is eating and drinking, please?
All right. Are you eating and drinking food? Drinking water or something and eating? So let me ask you this. Did you have breakfast?
Yes, I did today, yes.
All right. Did they give you lunch?
After a while, yeah, they did, yeah.
All right. Have they been giving you dinner?
We'll see if they give me it today. They haven't been giving me it for a while. I know what the problem is.
All right. So what I can tell you is this, miss. Unless you tell them there are specific dietary restrictions you have, everybody gets served the same thing. I've been over at the jail. I've watched them make the food, serve the food, because I'm always interested, and I was always interested as a defense attorney. If I have a client who's at the jail, I need to see what the jail is about.
Yes.
If I had a client who was at the state jail facility, I would go to the state jail facility because I want to know.
And here comes the gut punch finale. Mom waves power of attorney like a golden ticket, but Boyd shuts it down, because in criminal court, only the defendant or his lawyer can file motions. It's the ultimate catch, 22. Malik's too ill to proceed, but the case can't move to civil commitment until the criminal case ends. Translation: the jail stays the de facto psych ward. Drop your verdict. Is this justice on life support, or the system working exactly as voters designed it?
Where my client is. So what I can tell you is, for lunch, it's usually a bologna sandwich with some fruit. And do they give them milk or water?
This is Deputy West.
Yes.
Most of the time they get a vegetable, some type of dessert, bread, some type of meat, and some juice every day for lunch, for their 3 meals.
And then how long are they allowing the persons who have mental health issues to shower?
Anybody in regular, ma'am, they come out for 1 hour a day by the Texas jail standards.
All right. Thank you. Do y'all have any other questions?
Yes, Judge, because I know that's why they were motioning for Malik to be transferred to the rehabilitation center, because I did tons of research and that especially people with mental illness, that every time Malik has a schizophrenic episode or going into psychosis episode, he gets thrown into the isolation cell, which is, the all day, and then you get let out for 1 hour, which I know, especially for people with mental illness, could be considered cruel and unusual punishment, because their mental is already, low, and then it's declining more and more because then he doesn't get out. And usually I can tell you, Judge, my son, he was calling me like 5 or 6 times a day. And the last time I spoke to him was about 5 days ago. And he said, Mom, I feel my mental slipping again. And I said, well, Malik, tell them so they can help you. And then I never heard from him again. And so I got concerned and I called the jail myself a couple of days later. And they told me that he'd been thrown in isolation and he just left medical because now he was in an altercation.
Well, what I can tell you is this. When people go to the jail, if they have mental health issues, they get their classifications. And, this is why I tell everybody, you have to write to your legislature, because funding, nobody has funding. And so they have to make a determination what is safest for him. If he is having outbursts and there are mental health issues, general population may not be safest for him, because if he has a mental outburst or if he is having psychosis or something is going on and he strikes another inmate, that inmate is probably going to strike him back and there's going to be a big fight. So at the jail, they do try to classify people whether or not they should be in general population or not. Now, if he has a mental health diagnosis, which he does, they have nurses that will come in to see them to make sure they're taking their medication. Legally, they can't force them to take their medication. You have to have a court order for that, and that doesn't happen until you go to the civil court for forcing of medications. So the jail is really not the place for people who have mental health illnesses, but your problem is your son is sort of in a little bit of a limbo area. The reason why he's in limbo is he has a new case, and that new case has to be taken care of. But then he has the mental health issues. If he didn't have the new case that was open and pending, there would be more that I could do for him and more that his attorney could do for him. But right now, that new case needs to be taken care of. However they decide they're going to take care of it, whether it ends up in a jury trial or what. And then, the other placement and all of those issues can be addressed. But with what he's charged with, there's not going to be a placement that will take him, because they're looking at potential civil liability, because they know what he's charged with and that it's alleged to be a violent offense. I don't take it as true because I haven't heard any evidence. And so there is no other facility that's outside the realm of a facility for people who have charges like these that would accept him, because they're looking at different liabilities and they have their governmental standards that they have to abide by on who they can accept. But what I can tell you, if you have a concern about his safety or anything, of course, you can always let this court know, and you can always go to the jail or call the jail and let them know, hey, these are my concerns, and they'll address them. You just have to make sure you let them know.
And Judge, one more question. Instead of him being in the isolation, is it possible to be transferred to the hospital setting?
What I will tell you is they're in charge of transportation. They're in charge of whether they're in isolation or not, because the jail is in charge of safety and security. I have no control over that.
Yes.
Whether or not he's transported to a facility for mental health, that really depends on certain motions that his attorney filed, and then certain rulings that are made by the court that would hear that. And that's a quasi-civil matter because it has to do with mental health.
And that's another thing, Judge. What if we can't get the court-appointed attorney to file any motions?
Oh, so here's the thing. This is what I tell families. You may think a court-appointed attorney is moving slowly. Sometimes people will say, oh, this court-appointed attorney, I just don't like them. I think they're horrible.
Well, he's a very nice man.
No. Let me just tell you. And then you know what they do? They go out and hire someone. And then the people who know who the attorneys are, they are stunned that they let such a good attorney go, and that attorney was basically free. So what I can tell you too, sometimes attorneys, they're very busy and they already know that your son is an adult.
Yes.
So really, they don't have to bring you into the conversation because he's an adult. And I would always tell clients, look, I can't bring your parents into this conversation because what we're saying is confidential. And then sometimes if I'm bringing your parents into the conversation every day, then I can't work on your case because I'm busy having a conversation with your family every day. So what I can tell you is this: the attorney that was appointed to represent your son, if he was not qualified to handle these type of cases, he would not have been appointed to represent your son. Okay?
And am I allowed, Judge, if I have power of attorney and also medical durable power of attorney over Malik, can I file motions pro se on his behalf?
All right, so let me explain something to you. Now you're asking me legal questions, and I'm not allowed to act as an attorney or give anyone legal advice.
Okay.
But I would suggest to you to call his attorney.
Yes, ma'am. Okay. Thank you, Judge. Thank you for doing this for me. I really appreciate this. Thank you.
You're welcome. I understand. All right. You're welcome. You're welcome. And if you talk to his attorney, I'm sure his attorney will speak to you. All right. Thank you. All right, Deputy Laura, can you let him know he can be excused, Norma?
She did there.
All right. Thank you, Deputy, for bringing him.
With the pump looking clear.